All right, and we're back in the Judiciary Committee and continuing to look at H89, and we're going to be joined by, hopefully David Cohen is there. David, are you there? And we need a different...
I am here. Someone else stopped my video, so I can't restart it.
Got it.
Okay, we're going to get you started. If you just wait a moment, we'll get you on the screen. Ah, there you are. There he is.
Hello, everyone.
All right, welcome. If you could identify yourself for the record. And
yeah, absolutely. So good morning. It's a pleasure to be here with you. My name is David Cohen. I'm a law professor at Drexel University's Thomas R. Klein School of Law in Philadelphia. I'm also a board member of the Abortion Care Network, a network of independent abortion clinics throughout the country. And I'm very excited to testify, talk with you this morning about H89, the Vermont Shield Law, and explain why I support it. It's a particular honor for me to talk with you today. I have many deep ties in Vermont. My family has had a second home in the Mad River Valley for 40 years, and I've spent much of my vacation time there. My wife's uncle lives in Putney for decades, and we gather there every year for a family reunion, enjoying everything Southern Vermont has to offer. And last but not least, my wife and I got engaged on the top of Mount Abraham 2 decades ago. It's a very special place. Also, on top of that, with Vermont's rich history of protecting individual rights related to the topics we're talking about today, reproductive rights and LGBT rights, I really am thrilled to be here. So on this bill, along with 2 other law professors, Rachel Rebouchet at Temple Law School and Greer Donnelly at Pitt Law, we've spent the last year studying the legal issues that arise with the overruling of Roe v. Wade. As Michelle talked about earlier, 14 states now ban abortion, and the best estimates are that in the next 2 years, it might be half of the states in the country. This bill helps Vermont in this new reality. Vermont cannot change the fact that many states have made abortion illegal. But what you can do with this bill is protect Vermont healthcare providers and people who travel to your state to obtain healthcare from the very real threat that other states pose. What I'm referring to, what Michelle talked about, is the threat that government officials and private individuals in other states will try to investigate, sue, or prosecute people in Vermont for providing lawful reproductive health care to people who travel from anti-abortion states to Vermont or who are temporarily in Vermont. That has not happened yet, but we're very close to that reality. Based on our expertise, we strongly believe this risk will intensify in the coming years as states seek to ban abortion not only in their borders, but also when their residents seek abortion care in other places, such as Vermont. So far, 7 states have enacted laws like the one that you are considering today. Connecticut was the first last May. Since then, New York, New Jersey, Delaware, Massachusetts, California, and just last week, Illinois have followed suit. Others, such as Colorado and Washington, are actively considering their own versions of very similar provisions. The exact provisions in each state's law vary, but they all touch on the same things that we're talking about today that Michelle went over in detail. These provisions will help ensure 2 things. First, they will serve a prophylactic purpose of preventing out-of-state actions. And second, if those actions do occur, they will help Vermonters mitigate their effects. In our post-Roe environment, this bill is essential to prevent other states from interfering with the safe and legal care that Vermont provides all, including travelers. Therefore, I urge you to pass this bill and join the other states that have been leading the way in this new environment. Thank you. I'm happy to talk about all of the questions that you had earlier and anything else on your mind.
we'll open it to questions for folks. And, start with Coach.
Thank you, Professor. It's interesting when you were going through the list, of states. It seems that there's a zone of protection for women and others around the country, in the Northeast, especially. Because there was only, I think there was only one state you didn't mention.
From the Northeast?
Yeah.
Yeah, Rhode Island and Maine are not on the list. I've heard Maine is contemplating a bill. I have not seen it yet. I've heard nothing about Rhode Island, but yes, you're right. The Northeastern states are at the forefront of this.
Thank you.
I'm sure there are lots of questions. Just hold it back. We'll start with Angela though. Thanks.
Hi there. Thank you for being here. One question I have, a fairly specific. It's on page 9 of our bill. I'm just wondering if line 15 provides 3 years as a sort of statute of limitations, if it's correct to use that term in this case. It seems like 3 years of protection, maybe. Is that standard?
You know, this is a cause of action or a claim that is very much like a tort. I mean, it's called tortious interference. Every state has different statute of limitations for torts. I don't know generally what Vermont statute of limitation is. If it's 3 years for other torts, I would think it would be appropriate to be 3 years here. I know here in Pennsylvania where I am, the general statute of limitations is 6 years. So if I were, you know, advocating for a similar provision here in Pennsylvania, I would say it should be 6. But as long as it's consistent with the general Vermont statute of limitations for similar claims, I would say this is appropriate.
Okay.
So can I ask you as a follow-up with that, Angela?
Yeah.
So how does the statute of limitations in the other state affect how our statute of limitations, or were you going to follow up?
Yeah, I was thinking, like, let's come at it from the other side.
Right.
So the way I read this as working would be that whatever the statute of limitations is in the other state, that is the window for the person to file that claim. That then starts the Vermont statute of limitations. This is about 3 years from that abusive claim being filed. So if, say, in Texas, SB8, someone could file a claim within 6 years, and they do it on the last day, then this starts a 3-year statute of limitations from there.
Do you have another follow-up question on that? Because I do.
Action after, maybe.
Yeah, I guess my question would be, is it the action being filed, or is it what happens if the action's filed and there's not a judgment or anything that really comes to Vermont until some time later? Would our statute of limitations be potentially told? And maybe that's more of a question for Michelle.
Good question. I mean, the way I read this, it says it engages or attempts to engage in abusive litigation. So maybe the statute of limitations goes from that entire litigation attempt. So however long that litigation lasts, that would be the engaging in. So it would be 3 years from sort of the culmination of the lawsuit.
Okay.
So that's in back in line 15 where it says the cause of action accrues. That's what you're referring to?
Oh wait, no, you're right. You're pointing to something that I wasn't looking at. After the cause of action. Oh.
That to me, so I read that to be like the date of the procedure or.
Yeah, but I think, so maybe there's some clarity that needs to be in the drafting here. Are we does that 3 years after the abusive cause of action accrues or this cause of action accrues? I think it's probably 3 years after this new cause of action, but I think there needs to be some clarity there. It's a good question. It's a good point to try and clarify with the amendment.
Okay, thank you.
All right. Are you good for now?
Yes, thank you.
Other questions?
I can ask the one I was.
Yes, yeah, go ahead.
Thanks, Professor. It's really great to have you here. Thank you. I have a question about page 5 in the early part of the bill around definitions. line 14, where there's an exception for legally protected healthcare activity does not include any service where professional standards of care aren't followed and or anti-discrimination. And so I don't know if you were listening earlier, but my mind is going to what about protection for patients if their provider is not following these laws? And the patient may not know that. And so doesn't that potentially render all of these protections now not available to the patient if their provider does something wrong?
So you're asking whether the patient can avail themselves of these protections, these shield protections, if the provider is providing, substandard level of care. So unfortunately, the way shield laws are drafted, and this is true everywhere, there's very little in here that protects the patient, because most of these contemplate a situation where the patient is in another state, and the patient being in the other state is subject to the court processes and the laws of that other state, right? You've got someone who, travels to Vermont on vacation, avails themselves of reproductive health care in Vermont, goes back to Texas. Now they're in Texas. Now they are subject to the summons and subpoenas and deposition notices and lawsuit processes of Texas. There's nothing the Vermont shield law or any shield law, if it's for something, in another state, does to help that person other than some of them protect the healthcare information, so protect the data that might be at the healthcare center, also protects their provider, right? So it protects their provider from being hauled into court in Texas or that other state. This exception, which is common to other shield laws, basically says we're not providing this protection if there's a malpractice lawsuit. So if that person goes back to Texas and decides, I was cared for in a substandard way, and I want to sue over malpractice, this shield law does not prevent that lawsuit from the patient. What sort of your question goes a step further. What if the patient doesn't know, but the provider does provide less than standard care? Does that mean the provider is now exempt from everything here? Yes, that would mean that, because none of these bills want to protect the provider who provides substandard care. And the patient, their data, I guess, would not be protected, although I did not see that in this bill in terms of data protection. It is in other states' bills. But the patient only gets protection under these shield law bills sort of by association with the provider, because the nature of the entire reason for this bill is that now the patient is somewhere else and has a connection with another state and is subject to that state's laws, while the provider is still in Vermont, or the helper or the funder is still in Vermont.
So I understand what you're saying, and I agree that in most cases, that's the case. But say that there's a patient that comes here from Texas and has an abortion and doesn't go back to Texas right away, and there's a lawsuit and they're requested to be extradited. And then it turns out that their provider, for some reason, wasn't appropriately certified or was, say they were lying about their certification. Now that patient is subject to extradition, correct?
So it would be the situation where the patient is in Vermont and is being criminally prosecuted in another state, right? Because that's extradition. And so the patient is being criminally prosecuted because right now patients are not subject to criminal prosecution in any state because there's exemptions. But imagine a world in which Oklahoma passes a bill that was just floated last week, or Arkansas, where no longer are we prosecuting the provider for illegal abortion, we're prosecuting the person who has the abortion. And so the person is an Arkansas resident normally, but they're in Vermont for whatever reason, school or vacation, and the Arkansas prosecutor tries to prosecute that Arkansas resident while they are in Vermont. And so that in that situation, and if the provider provides substandard level of care, then you are right, then they would be extraditable.
I have just one more follow-up question. So can you just describe a little bit why, to your knowledge, why this clause doesn't just say for something around in the instances of malpractice suits, and why it's so broad as to thus render the patient's rights under this no longer applicable?
In fact, I'm just reading the extradition provision.
Seems to me if it's all about malpractice, there could be a very specific, much more specific.
So, right, so it could say that. So I think it's more than just malpractice that happens if someone provides a substandard level of care. This bill doesn't include the licensure protections. That's in another bill that's being introduced separately. But in copying the language from the Massachusetts and other statutes that have put it all together in one, it's more than just malpractice, because you would want to be able to go after someone's license if they're providing substandard level of care. So it's both malpractice and licensure, I think, that need to be contemplated here in making sure that with this bill, shielding providers who are not saying providers can get away with malpractice. So the drafting could say something specific about malpractice and licensure instead of what you're talking about here to protect that patient in that, the scenario that you're talking about. Also just put under, another way to go about it in the extradition provision could include a provision, and under no circumstances will there be an extradition of a person who receives care for the patient who receives care, regardless of the level of care that the provider can give.
Thank you.
Tom?
Professor, so we're in that scenario where they came from another state, got services in Vermont, and then went back to their state, or before they went back to their state, I don't believe they would be subject to any jurisdiction of that state, and I don't believe they would be able to extradite them as long as they were in Vermont.
Oh, yeah, right. And that I think is one of the reasons that this is so tricky in terms of how what you're saying is how most people go about their world, their travel, their life in America. They think that if they go to another state, they are subject only to that state's laws. Think of gambling in Las Vegas before there was gambling allowed in a lot of other places, right? It was illegal in most places. People go to Las Vegas. No one thinks that their home prosecutor is going to prosecute them for gambling. Unfortunately, as my co-authors and I went through in our first paper about this, the jurisprudence from the U.S. Supreme Court and other courts is not so clear on this at all. In fact, there are a lot of ways in which states can try to capture someone who's outside their borders under their criminal and civil laws. Most states have, and the Supreme Court has given its blessing to this, a doctrine that says if there's an effect in our state, we can prosecute you. So, think of a state that believes that life begins at fertilization. If someone who's a resident of their state is pregnant, travels out of state, gets an abortion, the state could argue that the effect is you are depriving our state of a citizen of our state by murdering them. And under the jurisprudence from a lot of courts and the Supreme Court, I would like to argue personally that I think that that's not allowed, consistent with your question. I would have no confidence that that would be the decision from the courts, because there is so much ambiguity about this idea of extraterritorial jurisdiction. And that really underlies all these shield laws, because I think most people's intuition is very much the same as what you asked about. but there's just no certainty that that would be what the law is. And actually, there are some very prominent law professors who believe, even though that's our intuition is wrong, that states do have broad power to reach outside their borders into other states. And that is the whole reason for these shield laws, to make sure that, okay, if the states do try that, under some of the theories that I just mentioned, that states like Vermont would do everything they can to not participate in those. So I share your concern. I share your thought that this should not be allowed. I just am not sure that that is accurate under the law.
Good, Tom?
I think so.
Kate?
Thanks for being here. I guess I'm just curious, like you're saying, we are sort of moving into somewhat sort of uncharted territory on some level, and clearly wanting to make sure that we operate within the Constitution. And I guess I'm just curious if there's not to lead the question too much, but if there's anything you can share in all of the work that you've done that could help give us some sense of confidence that the approach that we're taking here is legitimate and constitutional.
Yeah, so there's a couple things. You're absolutely right. This is not, I wouldn't say exactly uncharted, but it's very uncommon territory. And these shield laws are novel. I mean, the first one came in early May. So we're talking, 9 months of experience with shield laws, and they really haven't been used yet. I think there's a couple things that should give you confidence. I wouldn't say certainty, but confidence. One is that the two clauses of the Constitution that have the most applicability here, this law has been drafted to deal with. So the full faith and credit clause and the extradition clause are the most relevant parts of the Constitution. On the extradition clause, as Michelle went over, if, say, an abortion provider in Vermont goes to Texas, performs illegal abortions, and comes back to Vermont, the extradition clause absolutely requires Vermont to extradite that provider because they were physically present in that other state. Without physical presence in that other state, the extradition clause is also very clear that extradition is not required. It is permissible, and many states have laws saying we will extradite even though the person was never in that state, but it is not required. And so what this shield law does is say, within this permissible form of extradition, we are going to take the option of not extraditing this group of people. I think that is clearly settled under the current law around extradition, that this is within states' authority to determine what they want to do in this permissible category. Am I confident 100% that this Supreme Court would agree with me? I am confident that based on the law from 200 years of extradition cases, yes, they should, but can I predict they wouldn't overturn that? If it had to do with abortion, I wouldn't predict that. But I'm confident that on the extradition piece, everything you're doing is consistent with the doctrine right now. On full faith and credit, as Michelle went over, the full faith and credit clause requires recognition and enforcement of foreign judgments. So if there's a judgment in another state, it has to be recognized in Vermont. There are two exceptions, and those are the two exceptions written into this law. If there was no personal jurisdiction over the defendant, or if the lawsuit were penal in nature, meaning punishment instead of compensatory. There is a shield provision in California that I think runs afoul of this. One of California's shield provisions says it's against the public policy of California to punish people who provide abortions. So we are not going to recognize any foreign judgments against abortion providers in California. As much as I appreciate the sentiment behind that bill, that is, under most people's reading of the Constitution and the cases right now, unconstitutional. I would not want to defend that provision in court, which is why it's great that this one is drafted focusing on the exception. The full faith and credit clause does not apply to deposition notices, subpoenas, summons, It only applies to final judgments. So again, states have voluntarily decided that if there is an out-of-state summons or subpoena request or deposition request for someone in our state, we will work with the out-of-state court to convert that to an in-state order so that that person then has to show up in court in that other state. That is voluntary, not required by the Constitution, but almost every state has a provision that says we will convert that out-of-state order into an in-state order so that we can then force the person in our state to appear for the deposition or summons or subpoena. But because it's voluntary, Vermont can, and that's what the other states have done, carve out from that an exception for these particular topics. It is constitutional to do so. So I think those are the two main constitutional provisions. And I think the way this bill is drafted gets around the concerns there. I do think it's important to note, and as a strong proponent of shield provisions, and I helped draft the first one, I think it is important to recognize that what is being done here does undercut a basic premise of how this country works, which is that states will cooperate with one another. And there's good reason for that, right? There's all sorts of ways it's important for states to cooperate with one another. But the reason for the shield bills is that when one state tries to tell another state that what's lawful in your state, we're going to come after, then that underlying principle of cooperation needs to disappear, needs to go away. Because for Texas or Alabama to tell Vermont or Connecticut that the people who are providing lawful care in your state are now illegal or law violators in our state, that itself, that is the affront to states' rights and recognition of our, varying state laws. So the shield bills are in a response to the breakdown in comity and cooperation. Is, I think, the underlying constitutional sort of structural concern here, but it's in response to something that I think is the first breach in this.
Thank you, that's helpful.
Karen.
Yes, thank you for sharing. And because you brought up the data protection piece, it makes me think of just a general question, because it sounds like you've had experience in a variety of the shield laws that are in development or have been put out there. Can you share more about the data protection that has been in some? Are there other things that our law, as it's currently drafted, does not include that you're seeing like, oh, that would be good to include this? Or any thoughts you have of looking at the larger context of shield laws that are in development?
I haven't yet had a chance, because I just got it yesterday afternoon, to look at the companion bill that has to do with licensure and medical malpractice. And I don't know if that includes anything related to protection of patient data. But I testified yesterday before the Washington legislature, the Washington state legislature, and they have a very detailed provision in their proposed bill that talks about all sorts of patient data, not just data stored at a health clinic, but also data that is in third-party internet search providers, because that is something that can be mined, healthcare tracking apps. They have provisions about wiretaps. I mean, it's a very extensive provision about protecting patient data so that Texas couldn't purchase data that's stored in Washington State. Now, Washington State has, Microsoft, so they have jurisdiction over Microsoft and some of the data they contain. I don't have the specifics of what exactly it covers, but I would encourage you to look at that bill, and I can forward that along to Michelle, who could share it, who could look at it too, because it's just in it's been introduced, it hasn't been passed. But the basic idea is that people's data, healthcare data, is stored in a lot of places, not just in healthcare centers. And to protect that data from anyone who might use it to try and legally harm someone in Vermont would be important.
Right. And then any other topics that you're seeing as a gap or an opportunity, just in comparison to other shield laws?
Right. I haven't looked at what exists I know Vermont is one of the more accessible states with respect to abortion, but there have been many states that have used their shield laws to pass other provisions related to reproductive health care in removing barriers that have existed for years. So for instance, in Connecticut, there had been a longstanding attempt to get the physician-only requirement so that nurse practitioners and physician's assistants who were within their standard of care could provide early abortion. And that had stalled for years. But with the momentum around the Shield bill, that was packaged in with the Shield bill. And so I haven't looked at detail at where Vermont stands with other things that affect reproductive health care and, broadening it to what some of my colleagues will talk about later today or tomorrow, LGBTQ health care, to use this as an opportunity to think about things beyond shielding. So that's one thing that some states have done with their shield provision. Illinois did that as well just a couple weeks ago. But I think the general shield provisions that I've seen in a bunch of these laws, this does cover all the bases.
Okay, thank you.
So we do have providers that you mentioned covered in Vermont.
Right.
Already.
Yeah.
So other questions? Because I have a few myself as well. So I guess I'd just like to, take a little higher level and run through some scenarios and kind of understand how this bill addresses those scenarios. Perhaps I'll take the easiest one first, which is a patient comes to Vermont and receives reproductive health care services in Vermont. And, a patient from, we use Texas, and then, later goes back to Texas. So what does this do to protect our providers and the patient in that scenario?
So if the patient goes back to Texas and now say they're a family member who disagrees with them getting an abortion, or a neighbor, or someone else tells people that they had an abortion, right? And in Texas, because of SB 8, there can be a civil lawsuit over the abortion. Now, again, I'm not 100% confident that it would be right that Texas would have jurisdiction over the provider, but I also can't speak with confidence that a court wouldn't decide that it did. And so, or a local prosecutor.
Wait one second. So you mean without the shield law, you're not sure?
Right.
Okay.
I'm saying that, well, even with the shield law, a Texas court could decide we have jurisdiction over this provider because they have cared for one of our patients under Texas law. What the shield provision does is says while that lawsuit's going on, and the Vermont provider is subpoenaed to testify or to be deposed as a part of this lawsuit, even possibly while they're deciding the issue of personal jurisdiction or any kind of jurisdiction, the Vermont courts will not convert those out-of-state subpoena requests and deposition requests to in-state orders, so that the Vermont provider will not have to participate in this abusive litigation over care that was legal and safe in Vermont. And that would also be true of the people who work at the clinic, and maybe there was someone who was in Vermont who helped this person get the abortion. It would also protect them from participating in this litigation. If the local district attorney decides to prosecute the provider because they say the provider murdered a Texan, then that Vermonter will not have to be extradited and will not be subject to the criminal orders or the criminal processes from Texas being converted to a Vermont order that you have to participate. And unlike civil lawsuits can go forward even if you don't show up and participate. There can be default judgments ordered against you if you don't participate. Criminal prosecutions cannot. So the criminal prosecution would, without Vermont participating in it, the Texas criminal prosecution not happen. So that's sort of the high-level protection here. in the scenario that you're talking about.
A couple follow-up questions with that. On the criminal prosecution side, this provider, though, has a winter home in Florida. Probably should sell that winter home and stick around Vermont.
Yeah, I mean, the reality of this new world we're living in is that the further away that providers get from caring in their state, in person, with patients from their state, and with licenses only in that state. Every time you sort of twist that fact scenario to add in other states, they are increasing their risk. Because you're correct, if this provider goes to Florida over the winter, they're not protected in Florida from the Texas governor asking the Florida governor to extradite this person who is now physically present in Florida for this criminal prosecution. And there's nothing Vermont can do other than saying we will not participate with what's in Vermont to assist that provider. So there's a lot of advice being given to providers right now about their travel, about their licensure. So say a Vermont doctor has a license also in Tennessee because they have family there, or they have their residency there, so they have their license there. A lot of providers are thinking, do I give up that license now? Because that license could make me subject to something in Tennessee that I don't want to have happen. It's a new world for providers.
Yeah, it's just, I think we need to be clear on what we can and can't do as far as protecting providers. So on the civil side, so a default, just to play out that scenario a little further, we don't honor any subpoenas or depositions or whatever, but nevertheless, there's a default judgment entered in Texas. How does this protect that provider at that point?
So once the default judgment is entered in Texas, the attorneys in Texas would have to come to Vermont to try and enforce that judgment. As the full faith and credit clause, Vermont has no option but to enforce that judgment. So the provider would be subject to paying that lawsuit result. But this is where the counter lawsuit provision comes in, that Vermont has created this tort of tortious interference with lawfully protected health care, that by trying to enforce that in a Vermont court, you have now violated this provision of the law, and the provider could countersue for the amount of recovery and get attorney's fees and costs as a result. This is a provision that is somewhat novel, although these are called clawback provisions. There are clawback provisions in other areas of the law. And so far, they have not been found to run afoul of the Constitution. And so that's how the Shield Law deals with that.
So doesn't it also deal with it in the section regarding foreign judgments if the Texas law is deemed to be penal?
Correct. So yes. So if we're talking about SB8, I think SB8 would be a clear example of something that's penal, because in order to get up to $10,000 or more, you don't have to show you were harmed whatsoever. So I think that would be clearly penal because it has nothing to do with compensating you for harm. But say you've got the patient's mother who sues and says this is a wrong, not under SB8, but under wrongful death because you have killed my grandchild. And they claim I get compensatory damages as a result. That would not be penal. That would be compensatory. So it would not fall under that exception. Now, maybe you wouldn't have personal jurisdiction over the doctor. So you've got the other exception. So you're right. That provision does track the constitutional exceptions to the full faith and credit clause. Okay.
So just a question about the penal nature of judgments. So we would probably need to understand the Second Circuit case law on this, as well as state law on what constitutes a penal judgment.
Yes, the courts, as they interpret this provision, would have to look to all of the jurisprudence under the full faith and credit clause, correct?
All right, so I'm going to take that bit about the jurisdiction and use that to jump into my second scenario, and that's the telemedicine scenario. The individual, the patient is in Texas. Our provider provides telemedicine, provides a prescription to the abortion drugs which are taken in Texas. Where are we now? What changes as far as the protections that we might be able to provide here?
So what changes here is that it increases the risk level to the provider, because now most states define medical care through telehealth as occurring where the patient is. So when the patient is physically in Vermont, it is no doubt that the care occurred in Vermont, right? No one's contesting that. If the patient is in Texas, even though the provider is in Vermont, the standard understanding of health law and telehealth law is that the action occurs in Texas. And so Texas will now perceive that the abortion occurred in Texas and have what they will believe will be a stronger case to make that this abortion is under our jurisdiction. And that would no longer raise sort of the questions of, can you apply your law extraterritorially? Now we've got, under general understandings of health law and telehealth law in particular, this did occur in Texas. Will still protect the provider from extradition, from subpoenas, from summons, from depositions, because those would still require the Texas courts to convert those things into Vermont orders in order to get jurisdiction over the provider. The risk, I think, though, is heightened for the provider, because I think Texas and other states will see this more as an affront to their actual abortion laws rather than sort of a stretch to apply to, into another state. And I think might take more aggressive action to try and enforce this, what they see as a criminal, they would probably see it as a murder or an abortion, and an illegal one. And so I think they would be more aggressive in doing so. And if I were personally advising a provider, I would say if you're going to engage in that telehealth into another state, you should absolutely do what you were contemplating before, which is limit your travel so that you are only in states with clear shield provisions that cover this. Because the definition of Massachusetts right now is the only state whose definition of legally protected healthcare covers what you're talking about. Because it has the same language that this bill does, that the legally protected healthcare includes care regardless of the patient's location. And so the SHIELD bill would protect the provider in Vermont, all the ways that we've been talking about all morning. But again, there's nothing Vermont can do to avoid Texas considering this person now to have violated their own law.
Let me tease that out a little bit, but we probably have a couple other questions as well. So we'll start with Ken and then Karen.
Thank you. So if a patient came to Vermont and picked up the pills and didn't take the pills here, but went back, because we keep using Texas, right? They went back to Texas and they took the pills there. Texas could enforce their laws because they didn't take the pills here, correct?
Texas could try to, and they would, I think, engage in all the things we were talking about already, start a prosecution, a civil lawsuit, try to get those things followed in Vermont. But I think you're right that pills create a scenario where the abortion can take place, or someone could say the abortion is taking place in many different places, because there's the act of prescribing and giving the pills. There's the act of taking the first set, then a second set, which is 24 hours later. And so right now there are abortion providers all over the country who are changing their protocols because of the risk that you're talking about, that they don't want. We don't know the legal answers yet to the questions you're asking. Where will different states determine the abortion takes place? So because this is also new. So for instance, there is an abortion clinic just over the river in Illinois from St. Louis in Missouri. In Missouri, abortion is illegal, and in Illinois, abortion is lawful. The abortion clinic in Illinois is telling its patients to take all the pills in Illinois before you go back home to St. Louis, because they are concerned about exactly what you're talking about. Now, there are many abortion clinics, and I don't know what the Vermont clinics are doing, that are not giving this advice. They're not making patients sign anything. I don't know how the Vermont clinics have evaluated that risk, but that risk is real. And there are attorney generals, for instance, in Tennessee, who have said that if any of the pills are taken in our state, we will consider that an abortion in our state, and we will prosecute to the extent we can. We haven't seen that happen yet, but the statements are out there that are creating the concern, and we don't have answers. But a shield law like this would protect the provider in all the ways that we've talked about. If another state took the reading that you're talking about and said, because you took the pills in our state, we're going to go forward with some legal action, the shield law would apply.
Follow up if you don't mind.
Sure.
So I'm going to be clever here, and usually I'm not. If that person got back on an airplane, you don't know where you are when you pop that first pill, right? And they're flying to another destination, and they stay overnight or whatever, and they wait till 24 hours. They jump back on another airplane, they pop the other pill. There's no way anybody's ever going to figure out what state that happened in, correct?
There's major problems of proof here. And so, figuring out the actual evidence that's needed to determine when someone and where someone took the pills is a completely separate question, right? But I think regardless of the proof questions, you could have, and you do have, state attorney generals and district attorneys who will see any connection with our state in relation to a medication abortion will create enough jurisdiction.
But you're still going to have, in the court of law, you're still going to have to prove that.
Correct.
That's going to be, you're going to have to prove that evidence. And boy, you're really creating jobs for lawyers now on that. Thanks.
Karen.
Yes, just really appreciating this conversation because I feel like it is giving me more understanding of the new landscape we're entering in as a country with regarding this full faith and credit of states honoring each other's laws and judgments, and really seeing that since there isn't at the national level, kind of this isn't being regulated or enforced. Now it's state versus state potentially. And that just is a real shift for wow, okay, we're entering this. And it's making me curious if there are, because our focus is on reproductive rights and gender affirming healthcare. But it really could be anything that is allowed in one state and not the other state. I think you used gambling as one. So I'm curious, are there shield laws for other things outside of reproductive? Is that something we should be considering, like looking at it bigger picture, not, I'm just thinking like down the road, like this is opening a door to a whole new world of how we look at things, and curious your thoughts on that.
You're entirely right. I mean, this was the premise of the first article that my co-authors and I wrote about this. We called it the new abortion battleground, and we said that the interjurisdictional abortion wars are coming. That's a quote from the article, because without the national right, you're going to have these interjurisdictional battles. That's the entire premise of the shield laws and what we've been working on. I don't think there is a need for shield laws on other things yet, because the variation that we have from state to state on a lot of things that doesn't create the concern of any kind of legal blowback. Because they're just not politicized in the same way, right? You drive up from Pennsylvania to Maine, and you go through a bunch of different laws with respect to, say, purchasing fireworks. If I purchase fireworks in another state where I'm not allowed to here, my local prosecutor couldn't care less. It's not going to cause any uproar, right? Same with going to another state to gamble. The variation that we see among states, I think for the most part, just doesn't raise anyone's concerns about these things. Abortion is obviously different. Gender affirming healthcare has become different in the past year or two because they are so politicized that people are thinking it's not enough for me to stop abortion within my borders. I need to stop it everywhere. And so I don't think there's other issues that we see the same concerns over. So that's why right now shield laws are in the context of abortion and gender affirming care. Guns raise an issue where we see the sort of very different approaches in different states. But we haven't seen anyone trying to prosecute someone for going to another state and purchasing a gun and using a gun there. Certainly going to another state, purchasing a gun, bringing it back to the state where it's not legal to own that gun, that's a different question. But we don't have the same thing with gender affirming care and abortion where you're getting a product somewhere else and bringing it back. So that's why I think these are unique issues that we're seeing these shield provisions with respect to.
Thank you. But I don't know, it's unsettling for me hearing this of how it is transitioning more to the state versus state piece of us having to work things out. And just as we're talking, it's hitting me more of that's where we're potentially headed for things. So, yeah.
One more thing on the extradition. Is this something you're trying to forecast to try to prevent, or has there actually been an extradition from a demanding state where the crime was not committed?
There has not yet. This is all about preventing in the future, right? The hope is, the people who drafted the first bill in Connecticut were very clear. They said, we hope this bill is never used. We hope that the presence of this bill, along with hopefully the good judgment of the prosecutors in other states, will prevent any of our providers from ever being sought for caring for someone who comes from another state. So the hope is that these bills put up a shield, literally, to prevent this from happening in the first place. But if it does happen, and there are certainly attorney generals in some of the states and prosecutors, as local prosecutors as well, who have made public statements that they want to go after providers in other states. If it does happen, which it hasn't happened yet, these bills will be there to protect people. But it's also, it's important to stress we are, 7 months post the Supreme Court decision. And this is still just the very beginning of this new world. So, yeah.
Good, Tom?
Yeah, good, thank you.
Angela?
Thank you. So I have two questions. And I guess I'll stick with what we were just talking about. I think I'm sticking with it. I'm looking at page 5 of the bill, lines 12 and 13. And I know I recognize that we're kind of working in definitions here, but it says, such services shall be legally protected if the service is permitted under the laws of the state, regardless of the patient's location. Mm-hmm. Is this as far as we can go to protecting, to mentioning, calling out the patient's location and hopefully providing some protection? I of course, everything above it is relevant as well. And it's talking about the act or omission undertaken to aid or encourage, not so much the patient themselves.
Yeah. This is the language that is so far only in the Massachusetts Shield Bill, the 5 words, regardless of the patient's location. This has been the most controversial part of Shield provisions around the country. New York is currently, I think a New York bill New York passed its Shield bill last year, and they just, one house passed an amendment to the Shield bill to add in language like this. What this does is this says we are not only protecting providers who care for patients in person in our state, or who are physically in our state, we're protecting our providers who care for patients who are elsewhere. That is not being done yet anywhere in the country where, or I should clarify, that is not being done anywhere in the country where the patient is in a state where abortion is banned. So there are no abortion providers in, say, legal states who are caring via telehealth for patients in, say, Alabama, Tennessee, Texas. This language would basically say we are protecting providers in Vermont who do that. So if a Vermont provider decides they want to care for a patient in Alabama via telehealth, where the patient is in Alabama, this, regardless of the patient's location, would say the Shield provisions apply. Like I said, Massachusetts passed this provision. No provider has yet taken advantage of it to care for patients out of state because there are several logistical problems in terms of, finding a pharmacy that will ship into a state that is where it's banned, getting malpractice insurance to cover care that is illegal in another state. So providers are looking into this and they want to do this, just the logistics haven't been figured out yet. But you started your question by saying, is this language, I sort of heard your question to say, is this language enough? Is there more you could be doing to sort of help in this situation? And I do believe there is, because this definition applies only to the Shield provision. I think Michelle talked earlier about how definitions in one part of the law might be different than definitions in another part of the law. So this is lawfully protected healthcare activity for the Shield, but not for other parts of Vermont law. So there may be, and I haven't studied Vermont healthcare law, there may be other parts of Vermont law that say you can only care for patients who are, you have a license to care for and they are in your state, or you have a license in the state where they physically are when you're talking about telehealth. This would not protect the provider from violating other parts of Vermont law, which may prohibit this kind of action. So there have been suggestions by some who want to do this that the better approach would be to have a provision that says that this is a definition not only for the Shield law, but also for all of Vermont healthcare law, all of the state's healthcare law allows for this kind of telehealth into another state. So that would be a way to more broadly cover the scenario you're talking about. And again, I would have to, you would have to talk to an expert on Vermont healthcare law and telehealth law to know exactly where those provisions where that provision would have to be.
Gotcha.
Can I follow up unless you have another question on this?
My next question is a different.
Yeah, so what's the downside of doing what you just suggested?
So the downside, I think, is that it really would change telehealth, the understanding of telehealth from most telehealth sort of basic assumptions. The way telehealth has evolved in this country is that the law of the patient's state is what applies. That has generally been understood to be the case in order to protect patients' privacy, protect patients from abusive providers, and just to make sure that where the patient is, because that is where the harm will occur, right? If they get sick, that the patient is best protected if that home state is considered where the location of the care occurs. So I think people who have developed sort of the law of telehealth have operated under this assumption. So broadly changing something about how the law thinks of where the patient is located would run up against sort of some basic assumptions about telehealth. Now, to be clear, there are telehealth proponents and lawyers and advocates who say we should make that change because as the COVID epidemic showed us, telehealth is broadly used and people use it without thinking about where they are versus where their provider is, right? There were people who went to other states during COVID and stayed there because that was where they had resources and safety, but they wanted to talk to their provider who was someone else, and no one was thinking about where I was and what I was allowed to do. So I think there's currently a rethinking of state lines when it comes to telehealth, but we're in the beginnings of that. And so I think that broadly changing that definition under the health law is something that just hasn't happened yet.
So there seems to be two approaches or two issues here. One is specifically if there are other Vermont health laws that could undermine what we're trying to do with respect to reproductive healthcare and gender affirming healthcare. And then there's this broader change that would go to everything. So I'm a little concerned about going that latter step. Perhaps, we'll have our healthcare experts look more deeply to see what other laws might affect provision of these services that we're protecting here. So,
no, I agree. And so some people with these shield provisions have suggested, well, it should just be expanding or carving out the telehealth rules for reproductive health care and gender affirming care, because that's where we're seeing the crisis of people not being able to access that in their home states. And we've got to meet a crisis with sort of rethinking some basic assumptions. And so, that's the whole basis of this language, regardless of the patient's location. I just, to go back to the original question, there is a way to do it that it would more broadly cover everything that a provider might face, not just the shield issue.
So if I could ask one other question on this before we go to you, Angela, it's on the same topic. So with regard to the regardless of patient's location, I want to make sure I understand the implications or how far that goes. So if a case is brought in Vermont, this would be very much a choice of law provision that we would apply Vermont law protecting reproductive health if somebody tried to bring a case in Vermont. So that's straightforward. What else does this, so is this just saying that we are going to provide all these other protections that we have in the shield law in essentially the telehealth situation?
Correct.
Okay.
Because the original shield bill in Connecticut only applied to lawful care that was lawful in Connecticut, right? You want to only protect people who are doing lawful care in Connecticut. It is unlawful for a Connecticut licensed provider to use telehealth to care for someone who's physically present in Alabama. So nothing about that would be protected by the shield law. With this, regardless of the patient's location language, now that does protect the care that I just talked about, if it were a Vermont.
I'm going to ask one last question, then jump over because it relates to the same issue. Though slightly different is in that the foreign judgments issue, what we've just been talking about in telehealth is there would be jurisdiction in that issue, but we still have the issue of whether that's penal in nature. So there's a little less protection, even though we're extending it with the regardless of the patient's location. There are some differences and nuances in other parts of the.
Absolutely. The case law, I think, has been clear that if you use telehealth with a provider in one state and a patient in another state, that other state where the patient is has personal jurisdiction over that provider. So that is treated as if the provider is there for personal jurisdiction purposes, not for extradition purposes, but for personal jurisdiction purposes.
Great. Thank you, Angela, for the patience.
Oh, sure. That's, yeah. So I want to, maybe it's a shift a little bit to talk a little bit more about gender affirming care. And I'm thinking about it specifically considering the fact that it's a type of healthcare that will often occur over a longer period of time. So how are folks protected over the course of that treatment? Would a patient, for the optimal protection, maybe I'll just run through scenarios and out loud that are kind of going on in my mind. Like if a provider and a patient are in Vermont every time, like at every point of care? I don't even know if that's possible, but is that that would be, I guess, the safest way, the most protected? Maybe the least likely as well, though. So we've got a provider in Vermont, a patient who lives elsewhere, having to either return to Vermont or stay in Vermont. Is that patient vulnerable? I mean, every time they return home, wherever home may be, if they're not protected in that state. And I guess maybe we're not talking about this as much because we know with the abortion laws that are proliferating, or anti-abortion laws, and that proliferation is maybe on a different scale right now with gender affirming care, but thinking of what might happen.
Yeah. I mean, what you said is exactly right. I mean, I think we can liken it to medication abortion that takes place in many steps, right? And so certainly those steps are over a very condensed period of time. We're talking 24 to 48 hours, but they can take place in different locations. And so the more someone stays in a state where everything is legal, the safer they are and the safer their provider is. Every time you adjust that a little, and gender affirming care is over a longer period of time with more treatments, but every time you expand that to include other states, that the person is going back to a state where something may be illegal or subject to a lawsuit, you're increasing that person's risk. I don't think it would change the fact that the SHIELD law would still apply and say the provider is not going to be forced to participate in the civil lawsuits or be subject to extradition for that care, because the provider is in Vermont and the provider gets the protection of the SHIELD laws. And through protecting the provider, we are also protecting the patient, because the patient will not have that person testifying against them or something like that. So again, much of the protection of SHIELD laws for patients is tangential, because they are not the ones, the basic idea of the SHIELD law is that the patient is somewhere else. So they are subject to the laws of whatever state they go home to. But because the provider is protected, that will give some tangential protection to the patient from any legal action, because the provider will not be forced to participate in any action about it.
And that's the best we can do.
Unfortunately, I mean, yeah, that's the best that can happen, because even if, Vermont passes a law that says all of the, you obviously have your reproductive constitutional amendment, right? That these are rights, that a person is exercising this right. Once that person leaves, once that provider leaves Vermont, other states are going to see it differently, and Vermont can't change that.
So I know that David has to leave in just a couple minutes, but I'm just going to ask one quick follow-up question on the same kind of scenario where this gender affirming care, which would occur over a period of time. My understanding is that presumably the clinician would have to be licensed in the state where the patient is, and presumably, if this is going on, that clinician will lose their license in that state. My question is not getting into the licensing part, but if there's a lawsuit by the state for this against a clinician for practicing without a license, is that protected under the SHIELD law? Does that fall within the SHIELD law?
So it should, because the care is still lawful in Vermont, regardless of the patient's location. I do think this gets to the question that was asked before: what more can be done about the regardless of the patient's location? Because if Vermont law about licensing, which again, I haven't looked at Vermont licensing law, but if Vermont law about licensing has some provision that it violates Vermont licensing law to care for a patient in a state where you don't have a license.
Which I think is the case, and I do think that is the case. So,
if that's the case, then that is a perfect example of how this language could be more, is not broad enough to cover every scenario, because it protects the SHIELD. The SHIELD provisions are activated, but the provider may lose their Vermont license because they're doing something that violates their Vermont license, having nothing to do with what the other state is trying to penalize them for.
Right. All right, I appreciate that. And we're going to be taking more testimony today, tomorrow. It's possible if we may want to hear from you again next week if we are going to be adjusting this bill, and hopefully you can be available to speak with us again.
Thank you very much. I am happy to help however I can.
I really appreciate your time. Thank you.
Thank you.
Thank you.
Thank you.
All right, so we're going to break in just a minute, but I assume, Michelle, that you and Jen, maybe in talking with David, will talk about the issue we've just been talking about.
Yes, and I'm not sure the extent to which I'm allowed to talk about the other proposal, but I can say just in general, it does address issues around professional licensure for healthcare providers here who are engaged in legally protected healthcare activity. And whereas usually there are circumstances where if a license is suspended or revoked or something in another state, there's reciprocity with regard because we're part of compacts, things like that, and there are exceptions along the lines of what David was talking about.
But if we have to change anything in here as far as regardless of the other patient's location, or maybe it'll all be covered in that.
I think what he's talking about is more on the licensure and around insurance and things like that are going to be, I mean, I think you guys are welcome to maybe have Jen or somebody in and
I just want to make sure the intersection with what we just talked about as far as the lawsuits and stuff.
Yeah, we're coordinating.
Okay, all right, that's all. All right, so we are back at 1:00 with more testimony on this, and